my office has consistently said to the legislature of Maine, do what you think is the right thing. Now, that's what you're here to do. Don't be afraid to do what you think the right thing is in addressing bills the way you normally do. Just be mindful of issues. We have a lot of challenges these days on an interstate commerce basis also, and sometimes you may have an impact on interstate commerce that you don't anticipate when you enact something that leads us to, a lawsuit. But just you should do what you think is the right thing when you're dealing with the bills in front of you. Foreign investors in this sort of area of global trade, everyone is everywhere. And for example, a U.S. company would have to go to court to bring a challenge against a regulation under a state statute that governs them. If they have an affiliate that does business in a foreign country that can bring a challenge, they will do it under the treaty instead of in the way that we're used to under the court. But in terms of the qualifications they have to have in order to do business here, they should be the same.
Representative Shane.
Thank you, Senator. Obviously, I think what we are trying to do is inoculate ourselves from future difficulty by protecting it, by building building as big a wall around our statutes as possible, I suppose. And what the citizens have brought to us in several bills is it'll be a lot easier to protect our water if we own it. If we change Maine's absolute dominion rule into something more like a common ownership of water. Right now, I presume an international company could come in and say, own land, develop the land, extract the water, and say, well, you can't regulate this, we own it. It would be harder to make that case if they didn't own it. How does that interplay with international agreements?
I think what we would have to do is look at, if you were to make a change to the absolute dominion rule, the question is, and I don't have an answer for it today, are there vested rights in parties that already own property to the use of the water on that land or under that land? And then
so that certainly sounds like a takings.
I wouldn't want to reach a conclusion without some research, but I think that's the nature of the challenge that would be brought.
And I think that you just have to remember that there's a difference between ownership and regulation in the discussions that we've been having, that the state does currently even regulate groundwater.
Yeah, but I'm thinking under Natural Resources Protection Act, it's a little like the MTBE thing. We can make a demonstration that we're protecting other resources by protecting groundwater. We can do that on site law, I think. We're protecting water by protecting the area around significant aquifers, et cetera. But bulk water transport, I'm not sure we have such a clean case to say we're protecting resources. And if ever there were a law to be challenged on an international basis, that's the one I guess I would worry about.
Have other states confronted this issue?
But the state of California, which my counterpart out there reminds me is like the 6th largest economy in the world, they have borne the brunt of challenges. They've had, I think, 3 or 4 of these challenges, and so far they've been successful in defending their statutes. But the issue of being aware of the potential for the impact of all these treaties on state regulatory efforts, I think, is relatively new. Maine had the first Trade Policy Commission in the country. California was ahead of us in terms of the energy that they put into looking at these issues, but there now are the equivalent of our Trade Policy Commission in several other states, because you really need to kind of tune in and see where is this going, because the terms continue to be negotiated. And the federal government has really not, I think you see in the letter that the Trade Policy Commission sent to you, our concern has been that the federal government really has not been as mindful as we would like of the authority of states to regulate in their own spheres. What is your protection? What areas are you safer in than others to regulate? And again, I don't want to create an impression that you shouldn't do what you normally do when you're considering bills that are in front of you. You know, what the federal government has agreed to have covered under these different treaties. They're negotiating, for example, pipeline issues relative to natural gas. Well, water pipelines might end up in that picture as well. So the ongoing nature of it makes it kind of hard to pin down.
This issue I see as a pervasive issue for the whole legislature. And again, I don't know if we could direct the Attorney General's offices before next January to come back and make a presentation to the whole legislature, and it come out of staffing budget, which I know everybody's cutting down. But instead of having a blue ribbon commission, if she mentioned that there was someone that might ante up some money, that there might be some money out there. But I see this as a broader issue than just water extraction, and that I think a lot of us could be educated on this subject.
But the commission does have a small budget, and it may very well be possible to address the trade aspect of this issue through the commission, and our office would certainly support on the legal side of that. The other issues, I think the DEP and HHS have their own area involved with some of the other topics you're talking about, but we have legal support relevant to those that we would be, of course, happy to provide.
If we own the water, if we change the laws, in essence, it's in a public trust, are we a market participant, and can we regulate water and avoid the interstate commerce arguments?
I can hear the screams from upstairs if I answer this question without thinking about it. We should.
You don't have to answer. I was just thinking because we're a market participant in solid waste, for example, so we are able, in essence, to avoid some of those conflicts. Can that occur through a public trust?
I don't want to raise any specters of interstate commerce here either, just that that's a similar issue in that if you do things in a way that discriminates against out-of-state companies, you're going to have a constitutional problem. I think when you're talking about regulating a resource within the state, that's not an issue unless you do something that is directly discriminatory. I give you an example out of Connecticut, I believe, where they required the taxes on beer. It's the case that actually went, I think, all the way to the U.S. Supreme Court, were higher on beer that was produced outside of Connecticut than produced inside Connecticut. That does seem fairly apparent as a problem. Yeah. Those are the kinds of things that you have to worry about.
Because I presume there would be a serious interstate commerce issue there, but I was just curious in regard to the public trust. In essence, bottled water companies in Maine, an internationally owned bottled water company, they haven't used the international trade agreement arguments in some of the regulation that's been put on them or in some of the disputes that they have been involved in that has percolated through the court system. Why is that? Because couldn't they challenge, since they're an international corporation and some of these cases that have gone forward, they haven't raised that international trade argument, such as a private investor that you talked about earlier?
I think that you would have to ask them that question, but there certainly have not been anywhere near the number of challenges that there could have been already to date. I mean, still, if you look at the World Trade Organization's website, you'll see the vast amount of challenges still are in the area that we're more familiar with when we talk about trade, which is tariffs. And so these cases, although they may have a fairly dramatic effect in that if some challenge is brought that says your state law violates this treaty, then the federal government under the treaty has an obligation to do everything they can to get rid of that. And that may mean, punishing you financially for damages if they have to be paid or for refusing to repeal a law or something like that. But I would think that most companies want to have a positive image, and so coming in and challenging your law under an international treaty as opposed to in state court brings a very different message.
And just to clarify your statement earlier about the GATS and agreement and the U.S. Trade Representative's issue dealing with drinking water. Right now, they said that water is not going to be regulated by. Is that correct?
Well, this is part of the issue, is to define exactly what is covered. We think that the GATS does not cover water itself, but it might cover extraction of water in bulk.
I see. Okay, so probably another reason to have a report back.